Grant of probate versus grant of administration. When dealing with the estate of a deceased person, procedure is absolutely paramount, such that understanding which process needs to be followed is of critical importance to the person charged with selling the estate, known as the executor or personal representative. Critical to this procedure is determining which form of grant must be sought from the circuit division of the court to allow the executor to deal with the deceased person's estate, be it a grant of probate or a grant of administration. There are clear and distinct differences between a grant of probate and a grant of administration, as well as variants that apply to particular circumstances, either due to the insufficiency of the will or the deceased person having property in multiple jurisdictions that is subject to probate or administration. Grant of probate. A grant of probate is a court order that confirms that the will meets the legal requirements established by statute, that the executor has been appointed pursuant to the will and has accepted that appointment, the inventory of assets subject to probate in the deceased person's estate, how the distribution of the estate's assets is to be undertaken, and the acceptance by the beneficiaries of the estate to the distribution of the estate's assets. What distinguishes the grant of probate from other grants is the existence of a valid will, which has a named executor that is capable and willing to serve as executor and deals with all the deceased person's assets that are subject to probate. If all these conditions do not exist, another form of grant must be procured from the court to settle the estate. Grant of administration with will annexed. A grant of administration with will annexed operates in much the same way as a grant of probate, with the additional step of appointing an executor or personal representative to manage the estate according to the will and or dealing with assets that are not dealt with by the will. This particular grant is necessary where the will itself is legally valid, but the will does not name an executor personal representative or names an executor personal representative, but they are not willing or able to act, and no other executor personal representative is named or willing or able to act, or does not deal with all the deceased's estate. In such circumstances, the court grants a grant of probate to deal with the estate property under the will and a grant of administration with will annexed to deal with the estate property not included in the will. The applicant thus petitions the court to appoint an individual to serve as the executor personal representative and or confirm the distribution of assets that are not dealt with in the will. Until such time as the grant is rendered, no one has authority to deal with the deceased person's estate not covered by the will, as they must await the court's issuance of a grant of administration with will annexed. Grant of administration. A grant of administration is required when there is no will or the will is not valid and the court has not declared the will to be valid. In those circumstances, the applicant must petition the court to appoint an executive personal representative and confirm the methodology for distributing the deceased person's estate, which must be in conformity with statute in Alberta, the Wills and Succession Act. The appointment of the executor personal representative follows a priority ranking system set out in the Wills and Succession Act, unless the individual is incapable or unwilling to fulfill this role. The same applies to the distribution of the deceased person's estate, with a clearly defined methodology set out in the statute. No one has legal authority to deal with the deceased person's estate until the court has issued a grant of administration, appointing the executor personal representative, and authorizing the distribution plan for the identified assets of the estate. Grant of resealed probate administration. If the deceased person lived in one province, but also owned property in another province, the executor will oftentimes need to apply for a grant of probate or grant of administration or corresponding court order in the place where the deceased person lived, and then apply for a grant of resealed probate administration in the other province where the property is situated. A grant of resealed probate administration allows the executor to deal with the property situated in provinces other than the province of the decedent's last residence. For example, a grant of resealed probate administration might be necessary where the deceased person lived in Ontario but also owned land in Alberta, such that the executor would obtain in Ontario a certificate of appointment of a state trustee, the equivalent of an Alberta grant, and then proceed to attain in Alberta a grant of resealed probate administration. For legal matters related to grants of probate, grants of administration, and other aspects related to wills and estate planning, visit our website or contact our law firm as specified in the description to this video. Thank you.